Good afternoon, culture lovers, and welcome to another in our series of History Forum lectures held at the Museum of Nebraska History, the flagship museum for the Nebraska State Historical Society. I'm John Carter from the Research and Publications Division, and I want to welcome you here. And we also want to say a special thank you to the Nebraska State Historical Society Foundation, whose funding allows us to share this presentation with people all over the city of Lincoln via the government access channel. Today's presentation is part of a larger project that's a collaboration between the Nebraska State Historical Society and Nebraska Educational Telecommunications. We're working together to produce an hour-long primetime documentary that will air sometime early in 2008 that deals with the history of the beef industry in Nebraska, the industry that buoys up all of our various economies. Today's presentation, Resolution to Range War, is presented by Pippi van Slooten. Pippi came to us as a researcher for this project and has been looking into all sorts of really interesting aspects and well-camouflaged aspects to that cattle industry. She comes to us, like I said, with an interesting and varied background. She's finishing up a PhD in political science at the University of Nebraska, and had to take a little hiatus in her studies to go serve our country over in Iraq for about a year. Her research, as I said, has uncovered a lot of interesting things, not the least of which is how it is we managed not to have such bloodshed in Nebraska. Pippi van Slooten.
Thank you so much, John. It's definitely my pleasure to be here. I've greatly enjoyed my experiences here at the Historical Society. And finding this information actually was very, very interesting. As I was putting this together, I was wondering, how am I going to make the law interesting? How do you make statutes that, you know, even though I find going through the archives and going through crumbly bindings, you know, fascinating, how do you make it interesting for an audience? And in one of my own classes that I was sitting in, another student was talking about the origin of the Miranda warning. You know, you have the right to remain silent. And how she made it interesting for us was that she's like, think of him as a person. Miranda was a real person who really got in trouble and really went to jail. And ironically, he was eventually murdered. And the guy who killed him got off because he wasn't read his Miranda Act, his Miranda warning. So I thought that would be the best way. Also, I was talking this over with someone else as I was reading to him and going over my speech, my lecture. I asked him, how can I make this interesting? And he's like, talk about the people behind the statutes and behind the case studies. He's like, those are Nebraskans, those are us. And so that's where the real story is. And so that's what I'd like to do, share with you today, some stories of the other Nebraskans from an older time. So up here I have some interesting quotes for you. The bottom one I thought was the most fascinating about where the herd ended up from Dances with Wolves. So today though I'm going to be talking with you about the history of the Nebraska herd law. And the quote that I took from the beginning, no longer shooting out among ourselves, actually comes from the, I'm not sure if he's the former now, but from the Secretary of Agriculture from South Dakota. And I'll read the full quote of that because it's kind of interesting. He actually cites the Nebraska herd laws. So we'll get to that in a second. Okay. First, though, one of those interesting stories that kind of sets the scene, I actually found while doing a newspaper search, and it's from April 9th, 1892, the Omaha Daily Bee, where obviously the journalists were a little bit surprised at what was taking place in Wyoming, right next door. So, April 9th, 1892, the Omaha Bee, they're prepared for war. This is out of Casper, Wyoming. A cowpuncher came in from Powder River tonight and reports seeing a man hanging from a guy rope just north of Tisdale's ranch on Powder River. He saw the so-called rustlers on their way to a common center. He thinks the man is a notorious rustler that was working the range on Powder River and was surprised by the Army or the Montana cattlemen. Further down the article read, no one here doubts that the cattlemen from Texas to Montana are mixed up in this and that a most determined effort is being made to protect the cattle business in Wyoming. Bringing cattle from Texas and running them here off the free range is an exceedingly profitable business, and the cattlemen don't propose to see this industry run out of the country. Now further down it states the scene of the proposed battle. The Bighorn Basin is a country first explored by Father De Smet in 1839, and soon after was visited by the Hudson Bay River Fur Company. It used to be the home of the Crow Indians and has been the scene of many bloody battles, for the Indians loved this country and made a desperate effort to retain possession of it unrestricted. After the Indians had succumbed, various large cattle companies went to the country and for a time enjoyed great prosperity on the open range. On the track of the cattlemen, the ranchmen soon followed, and here's where the trouble started, and since then there has been more or less frequent fighting. Now remember, this is 1892 that they're reporting. The legislature, also quoted in the newspaper, the legislature took hold of the matter in Wyoming, and as the cattlemen were the strongest, they passed laws favoring that class. This added to the flames and made matters worse. Notices were served on certain cattlemen to leave the country or take the consequences. It was publicly stated that some of them would never be allowed to gather any cattle, and certain worthless people commenced to prey upon the cattlemen's stock and even went so far as an attempt to ship them out east from Billings, Montana. Exaggerated reports of how the rustlers were killing off stock for the fun of it were circulated purposefully to stir up the stockmen and arouse them into doing something violent to protect themselves. It is generally thought that these stories were manufactured out of whole cloth, but they have served their purpose, and as a consequence, the stockmen have banded together to protect themselves and their interests, and in all likelihood, the matter will end up in bloodshed on one of the other sides, one of them leaving the state. Further down, it states, it is Wyoming's chief industry. Outside of the railroads, the stockmen pay about 8/10 of the taxes in the state, and cattle raising on the open range has been the chief industry. Capitalists get ranchers to work for them and then quit the country, leaving the ranchmen to rustle for their own money. Then again, the legislature is so run that counties are deprived of their proper representation to represent these rustlers. The state constitution provides that each county shall have a senator and a representative, but things are so manipulated that 3 counties are not represented at all. And the statute books are full of class and self-legislation that work hardships on the ranchman and his country. The ranchman sees and knows this and attributes all of his wrongs to the cattle companies. And to keep even in the race, they don't say much when the rustlers are disposed to wrestle the cows of the big cattle companies. Both the cattlemen and the rustlers are wrong in the present state of affairs, and the state authorities are handicapped in doing much for either side, as the state has failed to protect the capitalists and has robbed the ranchmen of representation. And there doesn't even seem to be much hope for a peaceful termination of this affair. The Omaha Daily Bee, April 9th, 1892. Now, this is a portrait of Clay Allison. Even though he didn't participate particularly in the Johnson County War, which took place in Wyoming, he did participate in the Lincoln County War, which took place in New Mexico, so to show that the surrounding states around Nebraska had some turmoil going on because of bad laws that we're going to discuss soon. But I thought this picture was interesting because it shows that they're not the dangerous, calculating men that you see in the movies, but kind of a little bit not quite sure what to say about them, but here he shot himself in the foot while trying to rustle cattle. So it shows that, you know, these people are human and they make mistakes, and that it was a real time with real people. Here's the quote I was telling you about. 114 years later, the South Dakota Secretary of Agriculture wrote in the Dakota Voice that the, quote, open range is a traditional term that no longer means what it once did. Under the common law, which is the uncodified law created by judicial decisions, a livestock owner was strictly liable for damages caused by the wandering of his animals. The western states reversed the common law and gave free rein to livestock expansion. In the old cowboy days, this is according to the Secretary of Agriculture, in the old cowboy days, which roughly were the 1850s to the 1890s, open range meant a place where anyone, including a lot of foreign investors and speculators, could run their livestock and not pay for the grazing privileges. Eventually, western states adopted some version of the Nebraska herd law, which created some liability for animal trespass and gave some protection from crop damages to farmers. The rest of the world, which is what the Secretary of Agriculture states, may not understand our open range, but our law is accomplishing one of its goals. We no longer decide such disputes by shooting it out amongst ourselves. As the Wyoming and later the South Dakota stories illustrate, the problem was one of land legislation. And so here we kind of get into some of the problems that were occurring that led to gunfights in other surrounding states and to the establishment of the herd laws in Nebraska, which would be later emulated. So the problem was one of land legislation that didn't suit the needs of how land was actually being used out west. And as the Wyoming case clearly shows, the laws that were in place were not enacted with equity in mind at all. But the larger problem, linked to the loss of the open range and to conflict with the newly arriving ranchers and farmers, may have been federal laws. According to the 1897 Indian Land Cessions Report, land ownership in the Americas was granted to the colonial powers in one of three ways: right by discovery, right by conquest, or right by original occupancy. As more and more Europeans governments established colonies, they had to have a legal principle by which to establish their territorial claim and sovereignty against competing claims. So you have the Spanish coming in, and how do they just defend their claims against the British coming in, against the French, and regardless of the Indian claims, I guess, at the time. European grants and charters were worded so as to acknowledge the bearer's right to territory by discovery. But the right to land by discovery was contingent on actual possession and actual use of the land. You had to colonize it and improve it in order to declare it yours, meaning that if permanent settlements weren't established on the surveyed site, then the discovering nation could lose its claim on the land. Also, I was watching a special on TV about the Jonestown settlement, which is one of the first British settlements, and that was the reason why it had to survive. They showed early on how the settlers, the Indians, local Indians, I think the Powhatan, or the Indians in the groups, didn't really like or trust these settlers because originally there were Europeans who were raiding the coast and stealing Indians and taking them other places. And so they didn't quite trust this new colony that was going to be a permanent establishment. And so they frequently attacked the colony, and eventually they starved them out. And so they were getting on a boat and heading back home when they found more colonists heading forth. And the captain of that ship said, no, this colony must survive. And this could be one of the reasons why. If it didn't, the British could lose their claim on the New World. Under the Spanish, vacant lands, which were lands not improved upon, could be claimed and sold by the Crown for a profit without treaty. The U.S. would later adopt this policy, and it's part of the Homestead Act. After the American Revolution, the U.S. government asserted that it held an extension of the original colonial treaties to its territory by right of European discovery. A potential constitutional challenge arose when U.S. President Thomas Jefferson made the Louisiana Purchase. There, the Supreme Court found that the original indigenous land claims were valid and had to be extinguished before the U.S. could make land claims. The U.S. government extinguished these land claims by three ways. One, claiming land not in direct use or improved upon, the Spanish rule. Exchanging tribal lands for reservation lands, meaning you don't lose your land rights, you just get these lands instead. Requiring private ownership for limited acres as opposed to large-scale communal ownership. And this also leads to the loss of the open range. According to an article published by the Public Information Network regarding land grant reform, soon after the American Revolution, the U.S. government began transferring public land into private ownership. This was mainly done to generate revenue for the government and would be done again after the Civil War. So both times, after both wars, there were major economic problems, and selling off land became a way of generating revenue. The relevant federal laws which transferred public lands into private hands included the Land Act of 1796, not too long after the Revolution, the Preemption Act of 1841, the Homestead Act of 1862, and the Kincaid Act of 1904. Now, remember the date for the Kincaid Act, because later when we go into the case legislation, you'll see a lot of legislation occurs around the 1904 date and a lot of constitutional challenges to the herd law. Of the total percent of public land sold or granted by the U.S. government, 5% was granted to war veterans in the form of military bounties, which will later be discontinued, 12% was granted or sold to the railroads, and 25% became homesteads. The homestead figure, though, is subject to criticism because fraud and abuse were rampant during the early days of Western expansion. According to the Government Land Office, a commissioner appointed in 1885 by former President Grover Cleveland, whose name was Andrew Jackson Sparks, stated, quote, "I found that the magnificent estate of the nation in its public lands had been to a wide extent wasted under defective and improvident laws and through a laxity of public administration," end quote. So in order to curb such abuse, the 1862 Homestead Act was designed as, quote, "an act to secure homesteads to actual settlers on the public domain." You can see again the whispers of the old Spanish rule. But the Homestead Act was still open to abuse, as it was not designed for agriculture out in the arid West. The amount of acreage was too little of land for a viable farm without major public investment in irrigation. So homesteads near water sources were generally used as fronts for larger cattle operations under the pretense that the land was being used as a farm. Conflict arose when the land was actually purchased for a private farm, and that water source for open grazing land was now closed to a more profitable cattle operation. The Kincaid Act increased the amount of allowable acreage, but again, the major beneficiaries were the more profitable cattle operations. According to Russell C. Lang's Original Land Transfers of Nebraska, the public domain, which we're talking about, consisted of land belonging to the federal government, awaiting transfer to private individuals via this web of land laws, such as the ones mentioned earlier. Almost all of the land that will become the state of Nebraska, excluding military, Indian, and national forest reservations, belonged to the public domain. Land speculation out west involved acquiring public domain land at a cheap government rate and selling it off before land legislation opened up the area to settlement and glutted the market, lowering the prices. As mentioned earlier, land sales provide the federal government with much needed revenue, especially after the Revolutionary and Civil Wars. Now, one of the methods of purchasing public domain land was for speculators to use military land bounties, which were land grants to military personnel for war service. According to Keith Hawking's survey of land entry files of the General Land Office, from 1788 to 1855, the U.S. issued military land warrants in exchange for military service. Indians also, and this surprised me, Indians who served with the U.S. military during the Indian Wars and even during the Revolutionary War, the War of 1812, and so forth, who served with the U.S. military were eligible to receive land grants for land out west up until it was cut off at 1855. But as mentioned before, fraud and abuse of this system existed almost from the beginning. Examples cited by Lang include soldiers enlisting for land and then re-enlisting under a different name to have more land to sell. And for example, Rufus Putnam formed the New Ohio Company specifically to buy and sell military land warrants, which he did from a soapbox on New York's Wall Street. Also, Solomon Tift made $50,000, which is $900,000 in today's currency, by supposedly purchasing bounty warrants from Indian soldiers or their surviving kin and then reselling the land at a higher rate. I saw some of these bounty warrants that were purchased, and the Indian names looked a little weird, so I'm not sure if these were actual Indian names. It looked like anything that we would probably make up if we were going to make up an Indian name. In 1858, the federal government officially stopped issuing military land warrants. But the 1862 Homestead Act was amended after the Civil War so that Union soldiers could deduct service time from residency requirements under the Homestead Act. So they still received a benefit, they just didn't receive land outright. But it almost was the equivalent of receiving land outright, whereas others had to at least live on the land for 5 years. The soldiers could deduct however many years of service they had from the land requirement. So if they served 5 years, they could own the land outright. This meant that the veteran or his surviving widows or orphans could potentially own the land outright without having to develop it up for 5 years. Needless to say, the situation was ripe for abuse also. According to a Pennsylvania archive website, after the Battle of Gettysburg, an unidentified dead soldier was found near the town firehouse. He still clutched a picture of his 3 small children to his chest. People throughout the state and along the East Coast raised money for an orphanage in Gettysburg for the children left fatherless by the war. And Pennsylvania put forth the most amount of troops for the Civil War on the Union side. And of course, they had the bloody battle at Gettysburg. And their governor at the time, Governor Curtis, just really felt tremendously for these troops who lost their lives. So they really bent over backwards to provide orphanages and homes for the children who were left without fathers. The people throughout the state and along the East Coast raised money for these orphanages, but controversy didn't escape the National Soldiers Orphans Homestead, which was the first one established. The matron was dismissed amidst allegations of physical abuse linked to the orphanage's closure in 1877. In 1878, Henry N. Bowman and his brother-in-law, J.A. Moore, who both were Pennsylvania Civil War veterans, became owners of Whitehall Soldiers Orphan School. It was at this school that land speculator John A. Walker of Lincoln, Nebraska, found 21 orphans with veterans' lands benefits. This actually was an interesting case because I worked with the Pennsylvania State Historical Society, and they were really excited on their end, like, yeah, whatever happened to the land for these children? I mean, did they end up in Nebraska? And Lang's account kind of leaves that open to guess, well, yeah, all these 21 children ended up in Nebraska living in Lincoln with Walker. And I kind of think I found something to the contrary, but I'll let you be the judge. According to Lang's account, in 1884, Walker filed for 4,320 acres in Custer County, Nebraska, and he did so as the guardian of these 21 children. In Pennsylvania, the Orphans Court appointed guardians of children under the age of 13 only if estates were involved. In 1890, the Orphans Court in Carlisle, Pennsylvania, awarded the respective sections of land to the orphans, even in cases where the mother was still alive, but had remarried. So she lost out on this land option if she remarried. Also in 1890, a deed was registered in the Custer County Courthouse signing over property from one of the 21 Whitehall orphans. All would eventually be signed over, by Tract 1 in particular, John W. McLean, son of Civil War veteran Alexander McLean, via John A. Walters, his appointed guardian in Pennsylvania, to George A. Seabolt for $320. Seabolt would eventually sell the property as a C.H. Parmalee to complete the Parmalee Ranch. In 1892, Walters, acting as the guardian for all 21 orphans, eventually sold all of the land entitlements for $2 an acre. According to Russell Lang's account, the orphans apparently lived with Walters in Lincoln, Nebraska, but the historical record doesn't quite sync with this account. According to a 1900 Maryland census report, a 17-year-old James W. McLean, born in 1882 in Pennsylvania with Father Alexander, deceased, ended up an inmate at the St. James Homes for Boys in Baltimore, Maryland. If this is the same boy, then he would have been 2 years old at the time that the Pennsylvania Orphans Court appointed Walters the guardian of his estate, and he never left the East Coast or the state system. So the system wasn't perfect, even in Nebraska. But as the Government Land Office Commissioner Sparks stated in his scathing review of the 19th century land management system, quote, that the abuses of the public land laws are largely due to inefficient administration, to the conduct of weak or corrupt officials, and to erratic and fanciful decisions is undeniable. But that the laws themselves are defective and in want of adequate safeguards is also true. The vast machinery of the Land Department appears to have been devoted to the chief result of conveying the title of the United States to public lands upon fraudulent entries under strained construction of imperfect laws and upon illegal claims under public and private grants. So bad laws lead to bad outcomes. But specifically, why did Wyoming erupt into war and Nebraska didn't? One reason is the makeup of the people who settled here. And the other reason is the equity of legislation, such as the Nebraska herd laws. So who settled Wyoming? Well, according to T.A. Larson's History of Wyoming, and to several recent articles published in the Annals of Wyoming, Wyoming became a territory the same year the Transcontinental Railroad was completed, and the growth of the population was largely due to the Union Pacific Railroad. And it was, quote, cited that this was the first time that you had homesteaders coming through, not just homesteaders, we'll find that there are other people too, coming through by railroad, as opposed to by long wagon trains and by efforts that, so that by the time the first wave of homesteaders and settlers arrived, they really were coming, they were staking everything to make this claim. But now you had the railroad, and so you had people who really didn't have to stake everything in order to make this claim. So you have a different type of people that are settling by railroad. So this was the way that the first wave arrived to Wyoming by railroad. The other areas were settled by wagon train primarily. According to Robert Althorne's Westward to Britain, the railroad brought British investors who heard stories of the West, and they heard these romantic stories and tales of the West, and they're kind of disappointed when they saw the real West. But they also heard stories of 35 to 40% annual returns on the Wyoming cattle industry because cheap grazing land out there seemed inexhaustible. This was prior, though, to the mass arrival of small ranchers and homesteads. And according to D. Alexander Brown's Galvanized Yankees, the Transcontinental Railroad project also brought Southern Confederate soldiers out west. From 1848, which is the end of the Mexican War, to 1860, near the start of the Civil War, Indians attacked cattle drives to the miners and settlers of California. So Texas began driving its cattle to northern markets. But with the outbreak of the Civil War, President Lincoln declared a blockade of Texas and all southern states and banned trading with them. In 1864, a full-scale Indian war took advantage of the divided nation and raged through the thinly populated western states. So the goal became, let's get those states populated. Galvanized Yankees were Confederate Army POWs who swore allegiance and service to the U.S. Army in exchange for freedom from POW camps, which were rampant with disease and death. 6 regiments, and I was surprised at that number. I thought maybe a few soldiers, put with Union troops, but 6 entire regiments of former Confederate soldiers were active out west, and one of their duties included protecting surveying parties for the Union Pacific Railroad. After the war, no southern state would claim these Yankees, so some chose new identities and decided to remain out west. Of those, some became solid citizens. Others became gunfighters, cattle rustlers, and highwaymen. with obvious grudges against federal government and authority. Also after the war, the former Union Army continued to protect the Union Pacific workers from attacks by both Indians and whites. So you have the return of the Union Army to their normal tasks and some resettled Confederate soldiers. Most men carried guns at that time, and newspaper editors advised them to for their own safety. The railroads, as it was going along the way, created boom towns rather than stable communities of friends and neighbors. Often, a town was established ahead of law and order and ahead of local government, so towns were springing up pretty fast along the railroads. Concerning the equity of legislation, as the Omaha Bee article earlier stated, the laws were geared towards the ruling and moneyed class in Wyoming at the time. And this increased the tension between rustlers, foreign investors, and cattlemen seeking to increase their fortunes, and other displaced people looking to make a home out west. But while the legislation was geared towards the propertied class, inside the actual courts, the cattlemen felt that the juries were always against them and would always go for the rustlers because the juries were made up of homesteaders. Concerning the But while violence erupted in other states, Nebraska found another solution to the problem of federal land laws and to the loss of public grazing land. This solution was the hurt law statutes. The Nebraska hurt laws are a body of statutes regarding ranchers' liability for damages to herders' crops caused by trespassing livestock. In 1855, the first Nebraska territorial legislature passed 2 acts regarding the restraining of horses, sheep, and swine from running at large. These early hurt laws were enacted by a series of statutes that varied from county to county. So each county had its own version before there was one general hurt law. And these county-by-county variations began roughly in the 1850s. Later justices of the Nebraska Supreme Court, writing of the origins of the statutes, stated that there are no clear records of the floor debates on them prior to the revision of the statutes in the 1940s. The state Supreme Court stated in its opinion in the 1912 Barton versus Yuri case that this first territorial legislature most likely let the people vote on these statutes in some form of public referendum, and that would be challenged as being constitutional or unconstitutional. In 1857, the legislature updated the acts by adding sections on legal fences, enclosures, and on what damages could be assessed if an animal broke through these enclosures. And according to the 1866 Nebraska Revised Statutes, Chapter 1, in 1860, the original acts were repealed and then replaced by a more comprehensive language pertaining to all domestic animals. Under the developing hurt laws, farmers could seize trespassing animals which were grazing on what was now private property. So even though it looked like the animals were still grazing on open grazing land, they actually were now grazing on a homestead. And it could be seized by the farmer for damages. The seized animals could be used as a lien until the damages to the crops had been recovered. But the developing laws weren't perfect, just like the land laws. But the difference is that they were adaptable. So even though they weren't perfect, they were met with obvious challenges from both farmers and ranchers alike, but not on the battlefield, in the courtroom. Some of the contested issues that were the subject of decades of litigation include, what if the farmer didn't present an actual title to what had once been common grazing land in the court? Is it still common grazing land? What if the farmer seized the trespassing animal and sold it without going through the proper notification arbitration procedures stated in the statutes? And are the statutes constitutional? What about the rancher's protection against illegal search and seizure without due process of law? Can my property just be taken just because my calf wandered away? The series of case laws dealing with these issues will be discussed next, as will the resulting legislative changes and the Nebraska herd laws. This is where we get to the fun part, the part where the people are involved. Some of the stories are kind of bizarre, at least they were to me. An early test of the Nebraska hurt law statutes was Haggart v. Wallins in 1877. In this case, a rancher sued for the unlawful detention of his hog, which had trespassed on and caused damage to a neighbor's crops. Many hurt laws actually had to do with hogs originally, running wild through the fields and even across roads, scaring carriages and injuring drivers. So a lot of these early cases painted pictures to me of just hogs run wild, just eating everything and just overturning carts. So we'll see if that's actually the case. In this particular case, the decision of the lower court was affirmed by the Nebraska Supreme Court. Under the provisions of the hurt law, the hog could be detained as a lien against property damage. So this first case was a test of the legality of the hurt law, and it was upheld. The court further stated, quote, "It is the duty of a party taking up the stock under the provisions of the act in question to notify the owner," and this is stated in the statute, how to notify the owner, "if known, within a reasonable amount of time upon taking up the stock." So if you take the stock, you got to notify the owner. The notice certainly was sufficient in this case to give the defendant a lien on the property. The object of the law is to afford a speedy and inexpensive mode of ascertaining the damages sustained by the trespass of the stock upon cultivated lands. If either party is aggrieved by the award, he has the right to appeal. In Delaney v. Erickson in 1880, the decision of the lower court, which was in favor of the farmer whose crops had been damaged, was reversed in the rancher's favor. And this is another thing that was rare in the Wyoming courts. According to the court records, the action was originally brought by Erickson, who claimed damages on land that he was leasing. He wasn't the owner of the land. He alleged the damage was done by Delaney, who grazed his cattle and sheep there for 2 to 3 months during the summer of 1879. But Delaney counter-argued that, quote, the said land is and has always been uncultivated, unenclosed, wild prairie land. My animal is grazing on wild prairie land, and has been ever since the first settlement in Dodge County. And this has been common grazing land ever since for the cattle and sheep of the inhabitants. And from the earliest settlement in Dodge County, it has been the common custom of the inhabitants of said county and of the defendant to graze their cattle and sheep upon the land. And by the customs and laws of this state, the said land is common and free grazing land to all inhabitants, and that the defendant is, and for 10 years last past has been, a resident of said county, living on his own land, adjoining to that said land, the owner's property, and engaged in the business of agriculture, stock growing, and breeding. Here, the court had to face a slightly different challenge than just the legality of the herd law. It is the legality of common law. He's arguing under common law, my animals can graze there, and common law existed prior to the arrival of the herd law or this farmer. But the state Supreme Court found Delaney's common grazing argument compelling enough to write an extensive opinion regarding the history. They go into the history of English common law, through the colonies, through all the way up until that present day, regarding grazing and enclosures, before tracing the history of the Nebraska herd laws to that point. To just summarize, in their decision they state, quote, it cannot be denied that at common law, everyone was obligated at his peril to keep his domestic animals off the lands of another. And it made no difference whether such lands were enclosed, unenclosed, cultivated, or uncultivated. You were always responsible for your own animals. So the question before the court was whether the provision of English common law as applicable to the people of Nebraska, and if it is consistent with the herd law, and if it was inconsistent, one of them had to go. Free range existed prior to the enactment of the Homestead Law, but as the state began to be developed and sold by transactions at distant land offices, the cattle could not be taught to regard the mounds of the government surveyors, nor that invisible line was traced according to the common law around the property of every landholder. So can you blame a calf for wandering and eating? But as immigration and population increased, so did the need for stock to be kept off the land of others, hence the need for the herd laws. I liked this particular case law because it cites why there are herd laws to begin with and what the difference was from surrounding states. The court here recognized the right of both parties to exist, basically. Not only did the cattlemen have a right to ranch, but the homesteaders had a right to exist, a right to farm. And so the purpose of the herd law was to negotiate these differences. Quote, it is claimed, and possibly with justice, that the time has now arrived when, by reason of the great increase of the density of the population of the state and the enhanced value of grazing land, the owners of such land should be protected in its exclusive enjoyment, the same as land sown to crops. If the time has come for such a change, the legislature and not the courts is the place where it should be inaugurated. English common law is not applicable to Nebraska. So the herd laws, by this declaration, trump English common law. And this is the loss of common grazing land. This officially is the loss of open range. Herd laws restrict common law standing in that it is not applicable to uncultivated wild prairie land. So if that land is owned and you know it's owned, keep your cattle off. Therefore, the farmer is required to show original proof of ownership. Show us that that's your land now and not common grazing land, of what was once common grazing land, in order to receive the protection of the herd laws. But since the homesteader failed to do so in this case, the decision of the lower court is reversed and remanded. So a new trial to be, was ordered with show me proof, actual proof that you own this land now. The decision of the lower court in Butcher v. Wagner in 1882 was reversed and remanded by the state Supreme Court as well. In this case, 16 head of cattle had escaped from the herders and had damaged the farmer's crops. The farmer claimed the cattle as a lien against the damages and verbally notified the stock owner. The farmer and the rancher agreed to go to arbitration per the statute, but then the farmer backed out, claiming $5 in damages before surrendering the stock. I don't care what the arbitrator said. You give me $5 and I'll give you back your cattle. In the trial, the lower court found for the farmer under the herd law statute. Well, it's within his rights to do that. He seized the animal under herd law. He wanted $5 for the damages. But the high court disagreed, citing that the farmer refused to submit to arbitration per the statute and instead made an arbitrary demand for damages. And they say, what if he had cited $100 or $1,000 to get the cattle back? The law was designed to afford a speedy and inexpensive mode of adjusting damages committed by trespassing animals upon cultivated lands. The arbitrators view the premises soon after the injury and determine a fair amount to be paid. The owner of the stock may then pay the sum awarded and have the stock released. Whether it has been a substantial compliance with the law, the proceedings will be construed very liberally in order to sustain them. But the person taking up the stock acquires no lien unless he complies substantially with the terms of the statute. And this the defendants wholly failed to do. So there it states a limitation to what the farmer can claim under the herd law statutes. And here it states a clear protection to the rancher. This is also cited later when we go through the statutes. The case of Keith and Barton v. Tilford in 1882 also is the first of two cases that we mentioned where the herd law provisions are ruled to be insufficient in relieving the damage and the stress caused by massive, willful violation of the act. This one surprised me. In this case, 600 head of Keith and Barton's cattle destroyed a section of Tilford's corn. He responded in accordance with the herd law statutes. And notify the stock owners before taking up all 600 cattle as a lien against the damaged crop. But in the meantime, he had to feed and maintain, with his own crops, 600 head of cattle. So he sued for and won an additional $100 and costs. And I hope that that was a significant amount at the time. The stock owners appealed this ruling, stating that it went beyond the limits of the herd law statutes. He can't take additional money from us as well as damages for the crops. But the court disagreed. They stated that there should be an adequate protection in place for the cultivator of the soil to enjoy the fruits of his own labor. He's not raising crops to feed your cattle. This was grossly denied to the farmer in this case. Quote, the plaintiff below was the owner in possession of 19 acres of corn and 1 acre of sorghum. The herd of the defendants, consisting of about 600 head of cattle, ranged upon this field and destroyed the corn. To have pursued a remedy, the plaintiff must have impounded all of these cattle, that is, shut them up in a closed pen, or putting the most liberal construction upon the language of the statute, he must have restrained and confined and kept the cattle together in one place until the completion of the notice, arbitration, and payment of the damages by the owners, or the sale of the cattle to pay the damages, which would occupy anywhere from 4 days to 5 weeks. In the meantime, the cattle must not only be kept impounded, but furnished with food and water at the ultimate cost of the owner, to be sure, yet the immediate cost of the owner of the destroyed crops. We assume that no one would consider this to be an adequate remedy. In the case of Holmes v. Irwin in 1885, this is the first of two cases addressing the possible constitutional violations of the herd law. According to the Nebraska Supreme Court opinion, the plaintiff took up a cow belonging to the defendant, which had trespassed upon his land. The next day, he notified the defendant in writing that he had taken the cow and why, and of the amount of the damages and the name of the arbitrator. So far, he's following the herd law statute. The defendant took no notice of the matter, so he ignored it. He kind of took that notice and threw it away. So on the fourth day, the plaintiff filed the notice and an affidavit with the justice of the peace, who rendered a judgment on the matter. On the sixth day, the sheriff was executed to sell the cow and return the money to the justice of the peace. Over a month later, the defendant sued, alleging the following errors. It's like, where's my cow? The justice of the peace had no jurisdiction to render judgment against me. No court summons was ever issued or served to me on the matter. And I didn't have my day in court, nor was I notified of the pending sale of my cow. And the court had no legal authority to render this judgment on me. So he's challenging the whole herd law on its face. Now, while the High Court, the Supreme Court, held that the judgment of the justice of the peace was an award without binding effect on the law and was within the bounds of the statute, also, the defendant could have objected when he was first served notice rather than thrown it away, and that no summons was required because you were served notice that this is what's going on. And if he objected, that he should have named his own arbitrator. The defendant's case was dismissed, but one of the members of the court did have a significant dissent. Quote, if stock can be taken up and by summary proceeding sold, and the proceeds of the sale appropriated by the person taking up the stock, and the actual owner be denied the right of review, the result might be the perpetuation of gross wrongs. And this also got me to thinking, under this objection, it could be that the person who's losing the stock is guilty until proven innocent. And so that is a significant problem. But the High Court didn't want to deal with it, just ruled that yes, the cow could be taken because you did ignore the notice. So there were enough wrong things that the defendant did, but had the defendant did everything right, who knows how that could have gone. The issue was raised again in the case of Randall v. Gross in 1903, and there are a lot of challenges in 1903. Here, the plaintiff's 3 hogs damaged the defendant's crops to the sum of $10. So the defendant seized the hogs, but before he could serve notice on the plaintiff, and this was kind of interesting, simply took back his property without paying any of the damages demanded by the defendant. He just walked over and took his hogs. When the defendant took him to court, he challenged that the herd law was in violation of the Constitution and contrary to Nebraska state public policy. The lower court agreed, and the plaintiff was given judgment of the possession of the property in dispute. You can keep your hogs. And he got 1 cent in damages in court costs. The defendant, the farmer, appealed. In their review of the statutes, the Nebraska High Court found, first, the herd law statutes did not do away with the stock owner's common law liability for damage caused by his herd. So he said, basically the High Court said, your hogs did do damage to the farmer's property, and something has to be done. The purpose of the herd law was to provide a remedy and a means for recovery of those damages. But as Keith v. Tilford found earlier, it is not an exclusive remedy. And if the injured party does not abide by the terms of the statute, he acquires no lien and is subject to court costs. In addition, the plaintiff asserted that the provision of the herd law violated the 14th Amendment in permitting the taking of property without due process of law. The sale of property can be conducted by compelling arbitration rather than letting the stock owner have his day in court. But the court found that the herd law offers one remedy, and there is nothing to prevent the stock owner from going to trial. So the stock owner at any time can go back to trial and take his case to court. So this was not being denied. The common law worked well here before, but it just didn't work well in this instance. So under Randall v. Gross, they found there was no constitutional challenge, and again, that's why these are in red. These were potential challenges that were reversed, that basically the High Court said, no, there are no challenges here. Okay, in the case of Ming v. Coffey, this was regarding water rights. But what was interesting is that it also, the herd law was brought in. In this case, the court ruled for the lower landowner to use, for the right to use the stream despite the fact that it flowed past the upper landowner's property. The court reasoned that in Nebraska, common law had already been limited and overturned by statute, the herd laws being an example. In the case of Delaney v. Erickson, which was cited earlier, regarding the history of English common law and the evolution of Nebraska herd law, was cited as a precedent of overturning common law. The common law does not trump Nebraska state law. In the 1903 case of Tunnicliffe v. Fox, Fox was left as the executor over Mrs. Tunstler's estate at her death. But did she actually have property in use in Nebraska for him to claim? The problem was that while she grazed her livestock in Cherry County, Nebraska, they were actually ranched in Wyoming to avoid liability damage of the Nebraska herd laws. So even though she had cattle that were grazing in Nebraska and the executor was trying to claim that land that she had grazed on, they said, no, we're not going to count that as actual land because she was using it to avoid the laws of Nebraska. So such that the court ruled that the Nebraska ranch was not a viable ranch in Nebraska and was just an extension of the Wyoming property. Under Goff v. Byers and Company in 1903, the Byers brothers sued Goff for cattle he seized under the hurt laws. Goff took up the cattle as a lien against damages to the crops, but failed to notify the Byers brothers, who were the actual owners of the cattle, due to a mortgage lien. The court agreed that as a result of the right of due process was denied to the Byers brothers, they found that Goff had no standing to seize the cattle because the cattle were already seized under a mortgage. In 1903, there were several hurt law challenges brought, and these are just a few of them. In Heist v. Jacoby in 1904, a similar question was asked as to the South Dakota Secretary of Agriculture's question, which was mentioned earlier. So you can tell that we are slowly now entering into the modern era, and we're ending the last of our major court challenges and going into just a brief run-through of the actual statutes so you can see what they look like. Basically, in this case, the question before the Nebraska State Supreme Court was, is it negligence to let hogs run loose on the highways? This is interesting. In this case, Jacoby was driving down a road in his carriage when a pack of hogs left the crops that they were already destroying to race across the road, and they startled Jacoby's horses. Jacoby was thrown from the carriage, broke his arm, and tried to sue for damages under the hurt law. The Nebraska High Court ruled that the current hurt law only covered damages to crops, so that crop owner could sue under hurt law, but not damage to persons. It was only designed to resolve the disputes between farmers and ranchers. So the court stated it was the legislature's job to revise or expand the existing laws. The courts only interpret it. I think he should have gotten some damages for that. In the case of Sullen v. Winterer in 1906, this is the second case where the hurt law was insufficient to prevent massive, willful abuse. In this case, a farmer bought what was once common grazing land. He bought it, had a viable deed to it. He enclosed it according to the Nebraska hurt law statutes to designate as land in use. But one neighbor just continued to send his cattle over there to graze as before. He knew it was owned. He knew that guy had a deed. It was properly enclosed, but he's like, darn it, that was common grazing land, and it still is. The cattle owner would simply pay for the damages and continue next season to send his cattle over there to graze. The crop owner said that this amounted to leasing his land. And if you notice, the date of this is a little bit after the Kincaid Act. So I'm thinking that this is also a protest against the Kincaid Act, where prior to the Kincaid Act, what the ranchers wanted was, can the government at least lease us some land? If we can't own beyond a certain amount of acreage, can we at least lease some of the public land? The answer was no. On the Kincaid Act, they were allowed more acreage, but still it wasn't enough. So here, what the rancher's basically doing is leasing the rancher's land, the farmer's land. The crop owner said this amounted to a leasing of his land, and since it was preventing him from being able to farm his own land, he wanted an injunction issued. The High Court finally issued the injunction and cited earlier case law that hurt law is not an exclusive remedy against abuse. It just can't prevent every creative type of abuse. In Barton v. Yuri in 1912, this is our final constitutional challenge against the Nebraska hurt law. In this case, Barton wanted to run for city clerk in Omaha, but was barred from doing so by a recent voter-enacted law. Outraged, he sued that voter-enacted laws were unconstitutional, as the role of the legislature was to enact law, and that responsibility could not be subcontracted to another group. The High Court disagreed and cited the Nebraska hurt law as a precedent for voter-enacted legislation. The authority for the law ultimately resided with the people of the state. This was contrary to our opening discussion with the Wyoming legislature. In Goodwin v. Rosebud Cattle Company in 1924, in this case, the court ruled that an entire cattle company could be held liable for damages caused under a foreman's watch. And in Folan v. Mallender in 1986, a hired hand tried to help with a bull from another rancher that got loose and he was injured in the attempt. He tried to sue for damages under hurt law and lost. The court found that not only does the hurt law not cover this matter, but that no statute relieves an individual of his or her common law duty to care for his or her own safety. And 1986, too, was the first time I found her in the statutes. So what follows are some of the statutes that I found. These slides summarize the changes to the statute. Oh, first we have the examples of the case laws. And so you'll see that hurt law is actually mentioned, and this was the actual opinions that were put out. And again, okay. Now these are the actual changes to the statutes. First you have the Homestead Act in 1862, and this led to the arrival of a general herd law. In 1866, the Nebraska Revised Statutes, Chapter 1, Agriculture, was the first one that I found that specifically dealt with the herd laws. And these are the following sections that dealt specifically with the herd laws. In 1873, what we see is the general statutes under Chapter 2 now specifically states, whereas the others just had, and you'll see it in a second when I actually show you some of the statutes. This was the first time that it specifically stated an act for a general herd law to protect cultivated lands from trespass by stock. So before that, you had each county had its own herd laws. And now all those different county herd laws were subsumed under one general one. And here we have some of the amendments that took place. Here was the first time that I saw specifically, line by line, I think it was due to court challenges, what each person's responsibility is under the herd laws. And number 6 is an amendment that looks uncannily similar to the court case I read you, where, quote, if the rancher makes an offer for damages and the arbitrator agrees to it, but the injured party refuses it, then the case goes to trial. The injured party, the crop owner, pays court costs and damages are awarded. Section 10 is an interesting one. Obviously, since voters enacted the herd law, voters can retract it. So citizens can vote to suspend the law. And if you notice, under 1897, repealed, one of the sections that are repealed, voters no longer have the right to suspend the law. That's something that I noticed. So under here, you have also some changes that look to be the result of court challenges and possible due process violations. Here, in 1903, the herd laws completely changed and bore little to no resemblance to what I saw earlier. And you'll see that also as I show you the actual statutes. Before, it was pretty clear-cut. It said herd laws, and it stated who's responsible for what. In 1903, those things changed, and you see herd laws are basically just to do with animal maintenance, and a lot was gutted from the herd laws. And here are some of what the actual statutes look like. You see they're very short. And then they get more and more extensive. Okay. At this point, I'd like to go ahead and open it up to any questions. Thank you. Yes?
You talked about the Custer County man, John Walters.
Yes.
And the Orphans.
Yes.
There was a provision in the Homestead Act for executors to be appointed to dispose of the lands rightfully owned by orphans of homesteaders. So, if you're implying he was doing something wrong...
Oh, no.
And
that's a good point to raise.
Proceeds. In other words, and the proceeds of sales of that property were supposed to benefit the minors. So...
That's an excellent point. Yes, that's an excellent point. Yes, what he did was legal. What he did was not illegal. He legally became the guardian. He even went all the way to Pennsylvania to get this done. He did become legal guardian and executor of their estates. That the problem is we don't know for certain if the proceeds went to the orphans, and that's why I point out, at least in this one case, it may not have. So, but still, that doesn't mean that it was illegal at the time. And actually, I was talking with John about this too, because I'm like, oh my God, the poor orphans. And that's why I was pointing out that the laws were bad, and they opened the way to things like this to occur. So if the laws were better written and did allow for more ranching land, did allow for ranchers to ranch the way that they were used to, then you wouldn't have had things like this going on. You wouldn't have had creative uses of the law. So in some instances, and also there were the orphan trains where orphans were brought out to Nebraska. But in this particular case, it does look like some creative use of the system was occurring.
And I don't argue that.
Right.
I mean, there's been abuse in American politics since day one.
Right. And I didn't want to point to it as a political abuse.
Right. And I wanted to talk about the military warrants.
Oh, yes.
First of all, I'm almost certain a veteran could not go into the land office on June 21st and on June 22nd declare 5 years, that is 5 years later, declare 5 years of military service, because it had to have been during actual war.
Right.
And I don't recall there was a 5-year war. But so I just didn't want the impression to remain, unless you can tell me specific instances of a veteran declaring 5 years of residency but having been off to war to do it.
At the time, and you're right, they had to declare 5 years of active war service. But at the time, I think the nation was just so bereaved over what had happened, and I found this a lot in the Pennsylvania cases, that, and these were, especially in the cases of the widows and orphans, that they weren't going to really contest them that hard. That they were going to go ahead and allow them the deeds to the land. They weren't going to be as vigilant as they would in non-veteran cases. So it did look like there was some concern as to, let's go ahead and take that, let's go ahead and take care of these widows and orphans because of the sacrifices they already made.
I'm not sure how you're tying in Pennsylvania with Homestead.
Well, because I went through Pennsylvania to find basically the widows and orphans, and then their land, for most of the East Coast, the military war bounties before, and even the homestead lands, were for out west. So a lot of these people who were getting under the war bounties and under the veterans exemptions were from the East Coast. So for a lot of the cases of possible, I'll go ahead and use the word fraud, for possible fraud, were Civil War widows. And so what they would do was they say, go ahead, put my name on there, pay me the money, I'll come out there and show that, yes, I'm living on the land, but all they wanted was the money. They weren't leaving the East Coast to live out here. So a lot of these times, even though by our standards today, we're saying, oh, they're breaking the law, they're doing this and this. At the time, it seemed reasonable that they were taking care of those widows by, making sure they got money, making sure they had the ultimate sacrifice that was being paid. So a lot of times what I found in what I was reading, that there was a lot of extreme sympathy for either, especially for crippled vets who I had experienced so much that they're not going to challenge them on how many years did you serve, did you meet the requirements, at least in the cases that I found. There may have been cases where they did challenge that, maybe, I'd say maybe in the case of black vets or something like that, but in the case that I found, there wasn't this hardcore challenge of these people who had survived the war.
Are you talking about homestead applications?
Yes.
I guess I'd love it if you'd explain that more to me. I'm kind of not getting it, because it's a homesteader veteran who's allowing his war time to apply to residency of his proving up of his claim. Are you saying that some widows and orphans stepped into the spot?
The benefit was to the veteran or to his surviving heirs. It automatically transferred. It was not just
a homestead
right.
application.
Right.
So John Adams applied for
Okay.
a homestead in Custer County. He was killed in the Spanish-American. So tie that into how a widow or
Let's say John Adams was killed during the war.
Which war?
During the Civil War. Okay, John Adams was killed during the Civil War. The entitlement passed on to his widow, and if his widow remarried, to his orphans.
But he had to have applied for a homestead.
No, his widow, he automatically has entitlement. Do you understand? The entitlement is automatic. Let's say the widow in this instance. John Adams' widow can apply as long as she can show she's the widow of a veteran who died during the war.
You'll have to, I don't agree with that.
Okay, well, I can show you the Homestead Act, but yes, the entire.
I've read it.
Okay, yeah.
We can talk later.
Okay, I'm sorry.
Sorry, I didn't mean to interrupt your talk. It's an excellent talk.
Okay, thank you, and thank you everyone for this time. All right. I'm not quite sure how to turn off the technology, but are there any